sake of trial of the suit and the prayer for past of such.
Yes, where is your application?
My lord, may come to application at page 41, my lord.
Yes.
This is the application for Order 6, Rule 17 for
Partition suit.
partition suit, my lord. It's a partition suit. In this
Bona fide
application,
mistake of the fact one deed of sale could not be incorporated in this.
yes, ma'am. At the relevant point, I had no that deed because the original deed is with my brother. I'm expecting because the after my lord
The factum of execution could not be incorporated.
Incorporate, my lord. This
Because you are not aware of that.
I am not aware of it. I have verified this before the registration office, and as soon as getting the searching certified copy of the particular
Where have you said
document,
all this, sir?
my lord, it is stated in the supplementary affidavit.
Oh, supplementary affidavit.
Your lordship has granted leave to file supplementary affidavit.
Nothing there before him. How will he understand?
No, supplement. One
Last
supplement,
date,
Wait, sir. Did I call upon you? Please wait, sir.
last date, after hearing me, your lordship
is
has
different.
yes, my lord.
But these facts are not before the trial court.
No, my lord. No before this trial court. Because at the relevant point in time,
So the trial
these-
court cannot be faulted
my
for
lord,
passing this order.
no. Faulted, my lord.
Why?
Because
You did not
this
bring
is
this
not
fact.
the reason order. This is not the reasoned order.
You can come up anytime you like.
No, lordship.
Show me pleading in your supplementary affidavit. Have you served him a copy with the supplementary?
Yes, my lord. I have
When
served.
did you serve him?
My lord, on Monday, it was served.
Yes.
My lord, may come to page last annexure P5, P4 is it's an annexure of that deed which was procured on 17th May 2022, and the pleading was filed on 2nd May 2000. Was filed on 12th May 2022. As soon as the inspection, we got it, and pursuant to the information which gathered from the inspection, we filed this. And after that, we procured this deed, my lord, which is very much necessary for adding incorporation of 42 square feet of the land within the suit premises, which I omitted in the written statement.
So 42 square feet should be brought within the hotspot.
It is possession with my uncle. That is not the part of the uncle sold. Uncle sold it to my mother, and it is the part of the partition suit, Schedule A. It is the part of the Schedule A of the partition suit.
Yes, sir.
My lord, on the last.
Is it have you checked? Have you seen this title deed?
I have seen this study. My lord,
What do you have to say about the title deed?
my lord,
Is it a genuine document or you question the
that has to be
document?
considered in the trial, my lord. The only,
No. It's a certified copy at the end of that. Please understand.
my lord, in filing of amendment application is
What is the suit for?
suit for partition. Amendment.
Partition of
joint property. I am 50% owner. Admittedly, he is the 50% owner. My only point, only beseech your lordship that WS was written statement was filed in 2018. Amendment application was filed on 12th May 2022. This delay because petitioner has that
I'll
knowledge.
compensate you, sir. I will compensate
Yes,
you.
one only thing.
Yes,
my
yes.
lord. My lord, application of amendment was filed on 12th May 2022. Petitioner's submission is that he did not has the knowledge. Certified copy was obtained on 17th May 2022. After filing of amendment application, he got the certified copy. Schedule of the certified copy, and if your lordship kindly consider the schedule of the amendment, identical, my lord. He has the knowledge from the very beginning. Now he has.
I cannot go into the question of the amendment. Difficulty is the court cannot, while allowing or disallowing an amendment application, merits of the amendment I cannot go into.
Only thing is his conduct, my lord.
Yes, yes, that yes.
That is the only
Yes,
point.
merit I cannot go into. You
No,
know,
no,
you have a well settled, sir.
He suppressed
Whatever
his-
is there written there, merit of that document I cannot go into today.
Absolutely, my lord. Only thing is his conduct. He had the knowledge, he suppressed it,
I'll compensate you with cost.
as your lordship pleases. Otherwise, it
Yes,
has
you
to
pay
be-
cost.
Your lordship, please.
No, naturally, sir.
You direct me.
I will direct you.
You
So
direct-
how much you volunteer to pay?
Okay.
25,000?
My lord, that is too
How much?
high.
Tell me what is true. So what is reasonable according to you?
My lord,
Sir, you are my officer.
before going
Sir,
to,
you are my
my
officer.
lord, before compensating me,
No, compensation
kindly
is necessary. I'll
have a
provide
look
reasons for
to
that.
page
I'll provide
25.
reasons for
My
that.
lord, one thing, I'm paying, my lord.
No arguments on this.
My
You tell
lord,
me what
only
is
one
reasonable.
thing I want to
You
highlight
tell me
before
what
going-
is reasonable, sir. You tell me.
5,000.
Very well. Ashun. Unnecessarily
going
delaying
to-
this matter will not help
No,
or
no.
arguing this matter.
My lord, one thing I am like
Challenging, nothing. Nothing, no further. Mr. Sir, you are aware of the
No, no,
situation,
no.
sir. You have lost this very well. The order is a sketchy order.
Fine.
The learned judge was upset with your conduct. Upset, is it clear? Why will the learned judge pass such an order? Was upset with you. Sir, you have appeared in so many matters. What does your experience say? What does your experience say? He was upset with your conduct. Look what is happening. In a partition suit, he was about to perhaps proceed with the trial. And you took out this application.
Well,
Absolutely upset with your conduct.
expedite the trial
Yes.
No, not now.
My lord,
You have delayed
separate-
this.
with separate application.
Kindly
Hey,
consider-
separate application for
Yeah, your conduct is bad, sir.
My lord,
The lordship pleases, kindly direct the trial court for expedition.
No, not now. First, this amendment has to
একটা
go.
application করার সুযোগ দাও।
You file. I'll grant you liberty to file additional. You want to file anything else?
No.
Any additional written
No,
statement?
no.
Challenging the order dated 16th of April 2024. So no point in retaining extension of the interim.
No.
That is why it was not extended.
It
Oh, you
is-
put
it
it
is
as supplementary affidavit filed in court is taken on record. Yes, call the
Much
next matter.
Nothing on behalf of the opposite party, my lord, led by Mr.
My lord.
That is online.
I am appearing for the opposite party, my lord. My lord, I'm for the petitioner, my lord. I'm led by Mr. Supriyo Chatterjee, my lord. My lord,
Continue, sir. What
my lord, he's in court number 23, my lord. Second item, my lord. He will be just
When-
coming
when
in
you
2 to
want it,
3
when you
minutes,
want
my
it.
lord. My lord,
Next
pass over, my lord, pass over.
No password, sir. Next one.
No, my
If
lord.
you're not ready with the matter, sorry, sir.
My lord, in this matter, my lord, I am appearing for the opposite party.
Yes.
My lord, I pray for very short pass over.
No, I don't grant adjournments in these matters, sir. I'm very clear on this. When did the interim order expire, Mr. Rai? Mr. Rai,
Second, December Yes, my lord. 24, my lord. Second, December, my lord. second.
why did you not file the application in time?
My lord, one thing, my lord, I want to draw your lordship attention.
Yes,
How
sir.
my learned friend is prejudice.
Wait, Mr. Rai. He's in difficulty. You do not.
No, as a, that I am not opposing, my lord.
The learned learned member is a junior member of the bar. So kindly wait.
I cannot see, my lord. That is why, my lord.
Yes.
Yes, my lord. My lord, I'm not quite.
Tell me, yes. Why did you not file your application in time?
My lord, I'm not quite abreast with the matter, my lord.
You're not aware of the facts and you have come to argue over it. This is unfortunate, sir.
My lord, just 5 minutes, my lord. He will
No,
be
this
back.
is unfortunate. If you have not gone through the brief, you have come to argue. This is not expected. Before this court, senior or junior, I treat alike. But the question is, you have to come ready in matter, sir. You just can't hold a brief and come to court. Where is the order impugned?
My lord. Page number 6, my lord.
Commissioner,
Page 70 of the main application, my lord, impugned order.
how old is the witness? Where is your application for appointment of commissioner?
Uh,
Which page? Yes, Mr. Rai, which page is the application?
Page 55.
He has dysfunctional this syndrome, hemorrhage syndrome.
It was allowed. I do not understand, my lord. What is the problem in keeping
Dysfunctional. And what happened? Learn a strong objection. Adjournment
adjournment sought for granted 10,000 rupees cost?
is cost. Same position here. The client is suffering. You-
That is what, my lord, I precisely.
Client is suffering, and this will not help the cause by staying the matter.
No, that is what, my lord, I precisely am
Of the
saying.
matter. I'll dispose of this matter. I'll just reduce the cost. Cost will
Yes,
be
your lordship.
cost will
Cost, I am not inviting your lordship to. I will not argue so what the cost portion is concerned. It is discretion of the court.
no, the court has imposed the cost. So I will not
No,
just
it is for my lord to satisfy what will be the quantum. I am not arguing on that. So,
and
I want the matter be disposed of.
there is a serious issue. This
Yes.
dysfunctional uterine hemorrhage syndrome. So
And
I
he
think
cannot work, my lord. If your lordship witness, my lord knows very well this type of.
objection. Mr. Rai, you have raised strong objection. You are delaying the hearing. Look at this. Look at your objection. Advise your advocate who is appearing there. These matters have to go through. Tomorrow, if it is not allowed, ultimately, it does not adhere to the benefit of any of the parties. If you consent, then I can allow this with the cost.
My
Allow,
lord, if your lordship.
but you have to consent.
Yes, if your lordship kindly takes up tomorrow.
Yes, because Mr. Rai, this is not an issue which is before this court. So unless you consent, I
That is what. That is what, my lord, precisely I am inviting a
But
lordship.
at the end of the day, what is the use of sending back? I'll impose cost. Cost has to be paid. I'll impose the cost because of the adjournment, but I'll allow the application. Consider this and tell me.
As a lordship, my lord,
If I can send it back. But sending it back will also.
it will not any to benefit of the either of the parties, because ultimately the suit will be remain stayed. That is the problem in everything.
Correct,
So that's
correct.
why, my lord, may I allow me to come tomorrow
Yes, when you want. Tomorrow is
with the
Friday.
instruction?
Mr. Rai, tomorrow everything
Friday,
cannot.
yes, yes.
Because
I-
Friday are
I'll
other
be
matters.
here.
Yes, tell me a date.
Monday, my lord, as your lordship, my lord.
Client did not want to oppose the application, my lord.
Right. No, Mr. Rai, let him take instructions and
Yeah.
come.
No,
Mr. Your junior says that.
That is what, my lord.
son of the client.
So,
So
Hey,
I'll take it.
why you are projecting it like that?
Mr. Rai, I will take it up now. Or you have not talked with your senior. Talk to him first. You have
That
to
is
talk.
what, my lord, precisely at 2, my lord, if your lordship kindly takes up at 2.
Arguing the matter. So I will allow this because at the end of the day, this will not adhere to anyone's benefit, keeping it pending.
Any-
Your suit will be expedited. Talk to Mr. Rai and come, and thereafter I'll allow it because he is online. Had he been here,
That is what precisely the problem I am facing, my lord. If your lordship kindly takes up at 2, subject to my lord's convenience.
no, on another date, I'll take it up. Same position. Let it
As
remain
your lordship.
the same position. So it will be taken up, Mr. Rai.
No, I am not happy with
That's
that,
why
my lord.
1,000 cost you will not get. Some minimum cost you will get. I'll allow
No,
it.
I am not on the cost part also. I am not.
You see the same
Because the
draft.
cost,
You see the same photocopy of the certificate
yes,
is and look by looking at this, you cannot expect that that person will come to court.
that is what precisely, my lord, also very beginning, my lord, I have invited your lordship. I am not arguing on that aspect also.
It's a little less. I think it should be 20,000 cost. Take instructions. Mr. Chattopadhyay is here. He will.
That is what precisely I am inviting your lordship. Give me some accommodation. 2 or Monday, I'll come before your lordship and
Now, since you are here, it should be 20,000, Mr. Chattopadhyay. Monday or Tuesday. এই কবে আছে টিউসডে কতগুলো আছে ছোট ছোট সেম পজিশন বাট I'll decide it on that. I'll pass the order.
yes, I'll come back and
Monday. Come.
Monday. Get for your lordship.
Tuesday.
As your lordship pleases.
List on Tuesday. Any other order you want? Any other? You want? What orders, sir? You will do with what? What will you do with the order, sir? It will appear on Tuesday. I will dispose of on that date. Since you are here now, I'll direct you to the pay cost of 20,000 rupees. Nothing more than that. I forget the code, sir. You are seeking an adjournment in this matter, sir. Let us not go there. I've seen your syndrome, what you're suffering for. Mr. Rai has also acknowledged that. Everyone is aware of the situation. So that will be allowed, but your cost will remain. Yes, call the next.
Lordship, item number 3, Lordship, I'm appearing before the petitioner, Lordship. I'm led by Mr. Rohit Banerjee, Lordship. Lordship, I'm praying for a short passover, Lordship. He's on his legs before courtroom number 11, Lordship.
Petitioner's father. দরকার নেই, এটা। না, এটা বাদ, বাকিটা সব মিলে গেল। Yes. Let me go through the order, sir.
My lord, I'm led by Nazir Ahmed.
Lordship, I'm led by Mr. Rohit Banerjee for the petitioner, Lordship.
Yes, madam.
My lord, I'm led by
Lordship,
Mr. Nazir Ahmed is online, my lord.
Yes.
Lordship,
My lord, I'm praying for a Passover, my lord. Actually, my senior's car broke down, so he couldn't be here online. I'm just praying for a Passover.
For the online, he has to, he had a breakdown of his car. For that purpose, he cannot appear online. You are aware of the matter, madam. You are aware of the matter. What is the matter, madam?
My lord, actually, it's a transfer application, my lord. Under section, we have filed a divorce proceeding, my lord.
Who are you? Husband.
My lord, for the husband, my lord. The my lord,
You
the
want the,
my lord,
you
ideally,
want the application to be transferred.
my lord, it can be transferred. I have no problem with
You have
that.
no problem.
But there is a separate application under section 125 of CRPC. My lord.
125 was allowed.
My lord, I don't have.
125 was allowed.
That was ex parte, my lord. I have to.
125 was allowed. Yes or no?
My lord,
You
I
must be
don't-
aware of the facts, madam. Go through the brief.
Lord-
Have you read the previous order passed by this court?
Yes, my lord. But
What is the order passed by this court? Previous order. Place the order. Place the order. Place the previous order. Mr. Nazir Ahmed appeared on that date. Place the order.
it's online, my lord.
Difficulties, madam. You nowadays you people do not do the homework. You come and straight away appear in court. That is unfortunate. On the previous night, you do not sit in your chamber to go through the facts what is there, what order has been passed by this court. You do not,
Lordship,
even you are not interested to read that.
My lord, there was specific.
Lordship,
Are you arguing the matter or seeking an adjournment?
Lordship, I am led by Mr. Rohit Banerjee for
Submissions. Yes, place the order.
My lord, the client has not given me any instruction regarding the check because
Place the order. Mr. Pal, you have an order? Give her a copy of the order. No, you have a copy of the order with you. Download the order and place it.
my lord, the internet is not working in the room. Just give me 1 minute, my lord.
You have not paid
Yes, my lord, but
the maintenance
yes, my lord.
directed in terms of section 25.
My lord, I have
So this court had directed you
to bring.
to place a check for the entire amount that has fallen due. Where is the check?
My lord, I have no instructions from the client.
Where is
regarding
the
this.
client?
The client is not present in the court, my lord. I tried to reach.
Very well. Then I'll direct the client to be present personally in court. If your client considers that in a matrimonial suit,
These are
he
two
will
separate
permit the
proceedings,
suit
my
to
lord.
go on without making payment of maintenance, which is minimum necessity for him, for your wife, still your legally married wife, to conduct the case.
My lord, it's a transfer application, my lord. I
So,
have no problem with
I'm exercising jurisdiction under Article 227 of the Constitution of India.
that. Was not prayed for in.
Yeah,
the
I have
petition.
recorded that. In my order, I passed an order on 23rd December 2024. I've given reasons why I've recorded that. Madam, you cannot just say go and transfer the matter to somewhere else.
My lord, it is their prayer.
Maybe, but you are consenting to that prayer also.
My lord, then my
Very well. Then I'll direct your client to appear. Make up your mind, madam, whether she is ready and he is ready and willing to make payment or not. If he is not giving you instructions, I can adjourn this matter till tomorrow. Ascertain from him what instruction he has. Otherwise, I'll direct him to appear. I can enforce the orders passed by this court.
Sir.
This court is competent to enforce orders. Do not consider this court cannot enforce its orders. 125 application you will not pay. There's a direction for how many years you did not pay. What is this going on, madam? How will she fight the litigation?
My lord, I don't have instructions regarding.
Get the instruction. What were you doing? The learned advocate representing the opposite party would submit that she yet to receive any instructions from the opposite party, full stop, having regard thereto, let this matter stand adjourned and appear under the same heading. Thursday date down, it is made clear that if the order dated 23rd December 2024 is not complied with, appropriate order shall be issued on the next date. No, Thursday. Yes. Call the next matter. Same heading. Yes. Yes, sir. Yesterday you submitted. Sir, kindly take out that section once again.
May I make?
No, wait. Yes, please place. Yes. You are the owner of the property. Yesterday he made a submission. Look, I am a tenant. This is not applicable. And went off.
I was not present.
Mr. Sen.
Don't take me amiss, my lord. But this matter, sir, my lord, way down the list in the monthly list, my lord.
This has come up.
Secondly, my lord, matter is
Very well, Mr. Sen.
my lord,
So I have not signed the order. I have not signed the order. That is the reason why. Because you are not the owner. And this was the consideration. So I'll recall this order. Argue your matter now.
my lord, so far as the matter is concerned, my lord,
Argue. I'm giving a second opportunity. Argue your matter, Mr. Sen. Lady Bremon, what is this? Lady Superintendent, Postgraduate Mess, Calcutta University.
he has come up against an order whereby the learned trial judge has rejected his application under order 14 in one day for fixing up the matter, for hearing under preliminary, to frame up a preliminary issue and hear the matter. Whether there is a
No, also 7-2 has been rejected.
7
And determination of relationship has been made.
7-2 has been rejected in the
By holding. No, by holding.
Malad will kindly consider the
Yes,
order.
yes, yes.
7-2 has been rejected, Malad, earlier, Malad. While disposing of the petition under 7-2 of the act.
No, he has come up against which order, Mr. Sen?
Against them,
Mr. Sen, which order he has come up? 21st September order.
21st September. So the earlier order rejecting 7-2, 7-3 allowed that stand as on date.
Very well, Mr. Sen. It stands. Whatever. Mr. Sen, try and understand. It's Calcutta University.
My lord, that may be a case, my lord.
Hmm.
My lord, my lord will give me few minutes.
Yes, yes.
I will humbly submitting, my lord, after tracking out of the defense, my lord, he has made this application. His application has been rejected. Now the suit has proceeded. My evidence is almost complete. He is to cross-examine. Thereafter, my lord, in this position, my lord, he has not challenged the order under 7-2. My lord, the 7-2 order has reached its final.
You see, it is a larger issue. Mr. Sen, Mr. Sen, can you proceed against Calcutta University by a third party who is not competent to represent Calcutta University, Mr. Sen?
I am humbly submitting. My
He's
passed out, my lord, after taking evidence as a first issue.
no.
Well, keeping the matter pending here will serve no purpose.
No. Not first issue. Preliminary issue, if you want, I can direct
But preliminary issue
without prior to evidence.
no, without going into evidence.
Absolutely. On the basis of the materials on record.
Consider keeping the matter pending, my lord, will serve.
I
no
know, I'm
purpose.
not saying so. I'm not saying so.
My
I
lord,
want
my lord, there is a monthly list, my lord.
No, I'm recalling because that was under a different consideration. Yesterday, he came. So many matters are there, Mr. Sen. And he said, no, look here. I am exempted. It is the tenant who is also exempted. When I went to sign the order, I checked out, no, it is only in respect of the owner. So he is not exempted. But the question is different. There is another point.
My lord, itself, my lord, the first issue will be again adjudicated whether there
You
is
know,
a-
that adjudication under 7.2 has been made already.
Made.
So this is cannot be today. This point has to be considered.
No, it will be considered.
If you consent to that, I'll frame a preliminary issue. I'll
Decided, but
if you consent to this and send it back here and now.
it be court's order, my lord, that the preliminary issue be on the evidence on record, but he has not given any evidence till date.
Where is Mr. Chatterjee? No, ask him to come. Where is Mr. Chatterjee? Ask him to come. Mr. Sen, I'll take it up tomorrow morning.
Monday.
Miss- Monday, very well. After hearing the parties, the unsigned order dated 8 January 2024, 2025 is recalled. List this matter for further consideration on Monday. On Monday. Oh, there are so many matters. On Wednesday, under the same heading. Same heading. Under same heading.
Wednesday.
Maya. Mr. Sen, it's only at the time of signing saved me. Eh,
5 minutes, 40
No, look at him, huh? He had shot a penalty and given a clear goal. What will I tell him? Because I had accepted it. Wednesday, Mr. Sen, same heading. Yes, yes.
Item number 5, my lord.
My lord, item number 5, I am appearing on behalf of the petitioners, my lord.
Yesterday in the internet, I have seen my number is 5. Gautam Chatterjee. No. I am appearing. Yes, your lordship. I was led by the. इतुन कर रहे हम ही कंपनी का 3 4 5
My lord, in item number 5, I am appearing on behalf of the petitioners, my lord.
next week. Next week. Next month. Much of
Obliged.
much.
Okay.
Item number 6.
Mandatory
The format of the mediation application, logic is there with the comma. When both the parties are appearing, that is the difference. But here it ended in a non-starter. So my scope of mediation was very much limited. So in this case, yes. No, no. No, of course not. Yes. No. Of course not. No. Of course not.
Okay, sorry, sorry. No, sorry, sir. I'm sorry. I wanted to just have a correction. See, this division bench judgment of Delhi High Court is contra. That's all. Right. Right. No. Is correct. Correct, no, this is correct. This is correct. Yeah. Yes. 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 My lord, exactly. Yes. Mhm. 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 Yes, it is. Yes. All right. No, that's much better. That is God sent Millard. And why I interrupted is he can answer that also to let the know. Not with the intention. Yes, very good. Yeah. That is correct. That is logical.
And that yes, I only not for all cases because my case was that his cause of action is different from my cause of action. Particularly in this case, it is mandatory.
Yeah. If one would kindly see the page 8, the judgment starts and this, and if my lord will kindly come to page 25, page 18, paragraph 25. May I, if well, there is one thing is But my logic. Yes.
Now, the court will never know what was decided or what was made for proceeding. Because court says failure or anything. Failure means failure. So what was discussed? How did the court know? If the
Well, there is one more logic. One more logic is this, that the claim in my counterclaim can go up to the period I file my written statement after filing. On this. Yeah. Yes, well, I'm not disturbing. Huh? I will show. Yes. Yes, I am ready with that. Yes. Yes. Yeah. Yes. I have an answer to that. I will. Yes. I have a.
So regarding
So this is another thought which we come to the head. Or then not participate.
and only my claim was under litigation. So if they have anything, that was not done. Now, Lordship is guiding us. Lordship, before that, I should also place Lordship the format of mediation that is Lordship appended to the commercial court, the litigation, the litigation and settlement rules 2018 Lordship, the schedule 1 form 1. Okay. Lordship, the form 1 gives the mediation application form. Then Lordship, under the heading of dispute, under the heading detail of dispute, if Lordship kindly sees serial number 4, schedule 1 form 1, mediation application form. As per rule 3.1. This is the format in which I have to apply for the litigation mediation. Schedule 1 form 1. Mediation application form. The second heading, first heading is detail of parties. The second heading is detail of dispute. Now, serial number 4. Brief synopsis of the commercial dispute not to exceed 5,000. This was the format. Yes, no. Yes. If the party is
provided code is there, madam.
yes. If the party
Unless code is there, can we have a location? Come to this format and wait.
Because no, while I file the suit, I have to give this document also that I have complied with it, and then I'm filing the suit, commercial suit.
Not the application. What has proven? You are required to buy area report. Perhaps you are not required to file what was discussed here, and that is can never surface because then that okay with prejudice. Any observation made by the mediator.
No, that report is there is no such report at all. Only the part and that I complied with it. No, I'm not saying regarding the discussion, regarding that application form. I should not. No, no, then I should not. Now, Lordship, we have also filed another application under order 6, Lordship, that is at 360. Two applications I filed, one under order 7/11 and another under order 8/260, saying that the court does not have, that the cause of action is no part of the cause of action arose within the jurisdiction of that. That is Lordship at page 6. So maybe even if they have claimed, this court, particular court, does not have jurisdiction to decide. True, but yes, but oh, there is he can, but the court has to have the jurisdiction to decide. But Lordship, regarding the cause of action.
Yeah, yes, madam.
Lordship,
Madam, I'm carrying all those. I'm carrying. Madam, I won't disturb. I won't disturb my lord right now.
2021 has to be complied, Lordship. Section 2021 of the Code of Procedure has to be complied. Yes. Moreover, Lordship, his counterclaim doesn't even disclose any cause of action. Nothing.
May I? Madam, yes, my lord. Is yes, my lord, that is correct. Yes, my lord. Well, first point, may I just touch it as a broad line, as a synopsis, and thereafter I proceed with this. Well, so far the first point is there. I am just giving a synopsis of my argument. This is that counterclaim is an additional right. Counterclaim is an additional right given to a defendant. Okay, and the order 86A creates a dimming fix. If we kindly see order 8 rule 6. Dimming fixer. Okay. Dimming fixer. Acha. And the two expressions are used in the orders 86A. If my lord, just I. Counterclaim by the defendant. May I read also very small? A defendant in a suit may, in addition to his right of pleading or set off under Rule 6, set up by way of counterclaim against the claim of the plaintiff, any right or claim in respect of A. Rule 6A. Counterclaim of a defendant. May I read again. A defendant, man has got that? A defendant in a suit may, in addition to his right of pleading, set off under Rule 6, set by way of counterclaim against the claim, any right or claim in respect of cause of action accruing to the defendant against the plaintiff, either before or after filing the suit, but before the defendant has delivered his defense. I'm right pausing here for a moment. Well, now I'm applying only common sense. I will, and sometimes common sense beats that all. My claim in a counterclaim can be even after filing of a suit, and it can accrue. It can include my all other claims which I may have after filing of a suit and my before filing of my first statement. So suppose the law is to meet extreme. If she says that it was mandatory in a written state for the defendant to go for this process of 12A, then this becomes futile. I can't include anything after filing of the plaint, a cause of action which has accrued to me. Yes. Yes, ma'am. Before or after filing of the suit, to his right of pleading is set off under Rule 6, set up by way of counterclaim against the claim of the plaintiff, any right. Means it is not connected with his case or anything, or claim in respect of different after filing the suit or after filing the suit. Before, against the plaintiff. That is the cause of before and after, both. It takes into care both before and after. I just take 1 minute. When plaintiff files a suit, he will put up all his dispute which has been before, we were before the sun. Now, when I file a counterclaim, I have a larger period. And when I have a larger period, my period is not that only. I don't file a statement for 3 months. Then cause of action accruing within 3 months can also be included here. So I am not to go through. I can't go to this I can't file my written statement, or I will say to the suit court, pause the proceeding. Something has happened after filing of the suit. I will be going to the mediation. You postpone the suit for a period of 6 months. Entire purpose is refuted. But if I apply the common sense, no requirement of going into law, nothing of the kind, and it becomes. I mean, there are other points also. uh, and whether such count as a claim, damage or not. Now, my lord, we kindly see too. Is another important aspect. My lord, such counterclaims shall have the same effect as cross suit. The expression used is cross suit. My lord has got that? So as to enable the court to pronounce a final judgment in the said suit, both on the original side and on the counterclaim. Then, original claim and on the counterclaim. Yes. Yes, yes. Survive. Separate suit. That is per cross suit. Yes, now, yeah, come forward. What I am submitting is this, that this too is also creating a deeming fiction of law for certain purpose. Certain purpose is this, that if his claim go, I can continue with my counterclaim. That is what the cross suit and this legal fiction is brought. But when we call up the legal fiction, it means something which is not there, we treat it as like that. Means is not this. I say this is actually it is not. Actually it is not. Deeming fiction. Deeming fiction is only for a purpose, a particular purpose. If I for achieving purpose, suppose, my lord, I say for the cruelty, man and animal are same. That is only for the purpose of cruelty. It is not for the purpose of deeming that giving appointment to this. That is a hyper view. That's why I'm saying law is to meet extreme. So this legal, this is common sense, that legal fiction is created only for the purpose of serving a purpose which is given. Fiction. I'm saying 4 is fiction. 4 is a fiction. One can see this. Counterclaim shall be treated as plain and government fiction. Now, but rest of what rules governed by the rules applicable to the plaintiff. So, what plaintiff says, he has a right to file a written statement. Define it. Just a moment. Other rules will be there. Other rule, main rule is this: is file a written statement. Another example. I file counterclaim. He has a right to file a written statement. In that written statement, he can also make a counterclaim. And technically, and I also get another right to file my written statement on that counterclaim. This, like a ping pong game, can continue, my lord. This, if you make a counterclaim, other side gets a right. So, yes. But, my lord, what I'm saying, this, yes. So, what, how, yes. Yeah. Yes. Yes, sir. The answer is very simple. Yes, I'm coming to that. Better ends here. This fiction of this will be carried. I'm coming, my lord. I'm coming. Yes, my lord. This fiction will be very. Yes. I'm coming to this. This fiction, my lord, this fiction is under the Civil Procedure Code. No, my lord. But what I'm saying is this 6A Rule 4 is part of Civil Procedure Code. That I'm saying. This is the part of Civil Procedure Code. This legal fiction will be carried throughout Civil Procedure Code. But what I'm submitting is this. That legal. Kindly see section 12A now of the of this of the 12A, this commercial code act. That is answer is. But the 6A amendment was there earlier. No, my lord. No, not to my knowledge, my lord. My lord, my lord, this 12A is under Commercial Code Act 2015. This deeming fiction, my first argument is this: can it be extended to this? No, this. It can be extended. Yes. I'm coming. I'm straight coming. I'm straight coming. A suit which does not complete in contemporary urgent relief shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as a suit which does not contemplate. Here what they say is a plaint. It is not a suit. It is not a suit. Yes. But that I will come. I leave that point. Okay, I leave this point. Yes. Correct, madam. Just on this, on the first point, 1 minute only. I have in my first judgment, which I have enclosed, it is a deeming fiction in my this, and that the Supreme Court judgment, madam. Delhi's decision bench judgment, page 8. Page 8. Well, on this, my lord, we kindly just have a look at page 1 of my compilation at page 6. Yeah, I have given page 6. And my lord, we kindly come below B on the right hand side. It is well-known principle of construction. Yes, sir. In my right hand side of the B, which what we call, it is in the, just after. Yes, my lord. Just below that, 2 lines below. It is well-known principle of construction that in interpreting a provision creating a legal fiction, the court is to. My lord, it is part of para 6. Yes. Page 6. It is well-known principle of construction that in interpreting a provision creating a legal fiction, the court is to ascertain for what purpose the fiction is created, and after ascertaining this, court is to assume all those facts and consequences which are incidental to available corollaries to give effect to the fiction. Well, it is all to be assumed. But in construing the fiction, it is not to be extended beyond the purpose for which it is created, or beyond the language by the section by which it is created. A legal fiction is in terms enacted provision when one act is normally restricted to that act and cannot be extended to cover another act. When a state legislature make the registrar a person exercising the power of a registrar, a person authorized to audit the account of society under section 81, or person to hold an inquiry. But I'm not reading that. I'm leaving it at this point. Yes. There's, I'm, yes. Now I'm not, I'm crossing over to the second point. The second point is, my lord, the cause of action which they say in my counter is within, he says that there is no pleading or of necessary for that. Counter, it says that is the argument. They no, I'm saying there is no necessity. Yeah, I'm saying there is no necessity. There is no necessity of the pleading, and well, here are two questions very important. One is this is a dispute, international dispute, commercial dispute. One party is in, plaintiff is in the United States and I am in India. Plaintiff is, if one can you see the cost title, OGO USA registered or office in USA outside the jurisdiction. When there is a contract entered into by and between the parties, there is no agreement of applicability of Indian law or whatever law which is there. So either in that case, either private international law applies or international law applies in such case. They have chosen to. They have chosen to submit this joke. This is just neither here nor there. So now, my lord, in that situation, my lord, that won't help. That won't help. I'm just saying that they. I'm not. I don't need to go. I don't need to go to the. I don't need to go to that extent. I don't need to go to that extent. Though under the international law, the jurisdiction of a court of a country is the person who is available in the country. This is the concept of, I'm not going into that. I'm not going into that. But he has sold for price of goods sold and delivered number of transactions, etc. Yes, I'm not on that. But that I'm saying, what is his claim about? His claim about is price of goods sold. My independent suit is in respect of defective goods supplied by him in the same contract which are subject matter of the suit. He has asked for certain payment in respect of certain transactions. That particular cause of action, except one. Out of 17 contracts, 16 out of the 16 contracts, it is my counterclaim is arising out of supplies made by him, and in one only is independent of his, where I have claimed that I manufactured these goods at your on your order, and you did not take release of the goods, and you are required to pay price of the goods because the goods deteriorated. That is independent. I said I can bring it a cause of action under this, and then we have to come whether what kind of pleading is required for that purpose. Yes, but there is judgment on that. There is a judgment on that. My lord, if my lord kindly come to the page 76. My lord kindly come to the page 6. Page 76. Page 76. Uh, 12, sir. Yeah, I should. My lord, if my lord says to finish it fast, I will finish it fast. Uh, mm, my lord, I will try to move very fast. My lord, my lord wants that really this should be one such case where important and point, interesting point in this. In my lord, if my lord kindly come to page 81. Para 18. 18. 1-8. No, this is on the pleading and the forms required for the counter. There is no. Yes, sir. Well, I have Lakshmi Das the by. Yes, madam. The question has therefore to be considered on principle as to whether there is anything in law, statutory or otherwise, which precludes a court from treating a counterclaim as a plaint in cross suit. We are unable to see any. No doubt, the Civil Procedure Code prescribes the contents of the plaint, and it might very well be that a counterclaim which is to be treated as cross suit might not conform to all these requirements, but this by itself is not sufficient to deny to the court the power and jurisdiction to read and construe the pleading in a reasonable manner. If, for instance, what is really a plaint in a cross suit is made part of written statement, either by being made an annexure to it or as a part and parcel thereof, though described as a counterclaim, there could be no legal objection to the court treating the same as plain and granting such relief to the defendant as would have been open if the pleading had taken form of the plaint. Mr. Desai had to conclude that in such a case, the court was not prevented from separating the written statement proper form which was prescribed as a counterclaim and treating the latter as a cross suit. If so much is considered, it would then become merely a matter of degree as to whether counterclaim contains all the necessary requisites sufficient to be treated as a plaint, making a claim for the relief sought, and if it did, would it seem proper to hold that it would be open to the court to convert or treat the counterclaim as a plaint in the cross suit. To hold otherwise would be erect what is substance is a mere defect in the form of pleading into an instrument for denying what justice manifestly demands. We need only add that it was not suggested that there was anything in Order 8 Rule 6 or any other provisions of the code which led an embargo on the court adopting a course. But, The Order 6, Rule 17 of the Code provides an amendment of the pleadings, subject, of course, to the applicability of the proviso appended thereto, which is not applicable in the instant case. Such application ordinarily required to be considered liberally. It is also not much in doubt or dispute that amendment of a written statement deserve more liberal consideration than an application for amendment of the plaint. Order 8, Rule 9, again, subject to statutory interdict, enables. Yeah. The provisions of Order 8(6)(a) must be considered having regard to the opponent. The right to file counterclaim is an additional right. It may be filed in respect of any right or claim or cause of action thereof. However, must accrue before or after filing of the suit, but before the defendant raises defense. The respondent in his application for amended statement categorically raises a plea that cause of action for filing the counterclaim inter alia was said to have arisen at that time. It was so inexplicitly stated in the said application. The said application, in our opinion, was thus clearly not maintainable. The decision of this in this, etc. is this. Yeah, different. But what I'm saying, what I'm submitting is this on the pleading. This is crystal clear. No, there is nothing. There is zero. Out of 18, 19, 18 is his contract. No, one is, it is an agree. He's in his plaint. He says all cause of action is within. No, my lord. No. I'm just, when we take an alternative argument, all in the plaint he says all cause of action is arisen within jurisdiction of the court. My contract with him is within jurisdiction. I am within jurisdiction. Cause of action is within. Contract is within. Manufacturing is within. Everything is within. There is nothing which is outside. Now, that is what I'm saying is not needed. Cause of action, it can be anywhere in the world. I take it another way. My cause of action can be anywhere in the world. It is not needed. It is not there for. Yes. Now, for accrual of the cause of action, it could be, my lord, in Honolulu. If I have, I can file it here. Yes. Yes. No. Yes. It can be, my claim can be in Honolulu, my lord. That is right. That is exact. My lord, one judgment, one case has happened at Mumbai before Justice Sujata Manohar. A ship came to India and the fare was not paid or something dispute, and the ship owner company filed a suit at Bombay High Court. When they filed a suit at Bombay High Court, the defendant filed a counterclaim in respect of something where cause of action has origin in UK. Not at all, no connection with this. And when this point was taken, then the plaintiff says that his defense is not within jurisdiction and his can't be raised in counter claim. The court rejected it and rejected with this wonderful passage borrowed from this. If we kindly see the page 45. Justice Manohar was senior to Mrs. Pan. Much senior, my lord. Sujata. Yes, Sujata Manohar, Justice Sujata Manohar was earlier. No, both are celebrities. Both are in the legal circle. My lord, this luminaries, and they're still lighting. Still lighting. My lord, page, if my lord, you kindly see the page 48. My lord, there is one more point here. If this matter can be argued for an hour, then 227 is not applicable. That is what Supreme Court says. 227 is only for correction of manifest error. It is not for applicable. No, but no, I am not going. I'm not going. I'm not. Yes, my lord, yes. My lord, even look at page 731. page 48, sir. Page 48. Yes, yes, madam. Page 45 it starts. At page 48. Yeah, yes, my lord. Page, yes. A suit has been filed by Hamlin for damages for breach of contract Dutch firm which was outside the jurisdiction of English court. Hamlin and Kerr were not granted leave to. My lord, here they are referring to the judgment of the British court in paragraph 8, and thereafter Dutch firm instituted an action against the Hamlin. But this I was just, I won't read if my lord, I jump up that. It is true that Dutch firm had failed, would have failed, but this, and if you want to kindly see the last 6 lines of the first paragraph, under order 8(6)(a), once the suit is within. No, what is, yeah, yeah. So here we have it directly connected. Is for a different purpose. This kind of thing. Under orders, once a suit is within the jurisdiction of this court, defendant is entitled to file a counterclaim provided the counterclaim is within the four corners of Order 8, Rule 6(a). There is no provision under the Act that the counterclaim must also comply with the territorial jurisdiction. So 6(a), I comply pecuniary, yes. And one judgment I will cite, my lord, Garment Craft, which Supreme Court says no. 227 you can argue it is, if suppose, let me place it, my lord, let me place it. Let me just keep it. It is applicable. My just make, my lord. Power is there. Absolutely white. I admit. I admit. Yeah, I admit. I admit. I admit. I admit. No, power I'm not arguing, questioning. I'm not questioning power. I understood. I'm misunderstood. I'm misunderstood. No, not what I'm saying, not an appropriate case. Right. Yeah. Yeah. Yes. Yeah. Yeah. Well, one thing more. In their order 6(a) application, there is no pleading of that, no cause of action. Pleading is this, that it is separate from the main cause of action.
Order is to pay losses. A defendant in a suit has the right of pleading a set of mistake set up by way of counterclaim against the claim of defending any right or claim in respect of a cause of action accruing to the defendant against the plaintiff. Now, Lordship has seen a counterclaim. Nothing is mentioned how the cause of action arose, Lordship. That statement should be there. They have not complied with 6(a), Lordship itself. Lordship, their counterclaim, Lordship, it starts, Lordship, from page 46. From paragraph 41 onwards. Regarding how the cause of action, what is the cause of action? Lordship finally comes to page 46. Till paragraph 49. Lordship, I am also placing paragraph 40. The plaintiff has no claim, its claim is barred by limitation, suit should be the suit is liable to be dismissed. This is his written statement. 41. Now the defendant finds its counterclaim herein under. So the counterclaim starts from this paragraph. 42 in respect of a contract, 43 from some other thing, 44 some contract number is mentioned, 45 again from something, 46 is the summary, nothing, Lordship. So, Lordship, they have not stated, Lordship, what is the cause of action. Now, Lordship, they have stated that this cause of action is based on my cause of action. Lordship will kindly see my claim at page 90. There is a specific contract number mentioned, and he has also mentioned the contract number. They are all other different. Lordship, at page 19 in my claim at paragraph 4, I have said that whatever has arose, Lordship, that is from contract number is arising. Yes, they are not part. So, Lordship, please judgment my learned senior friend retired, Lordship. Here, Lordship, in paragraph number 9, Lordship, it says that the counterclaim therefore be filed against them under order 826. Yes, yes. The counterclaim was directly related to the same repairs. But here it is not the case. It is not the case that their claims are arising out of this my contract, Lordship. That same contract. So, Lordship, in my case, Lordship, they have not stated that. And moreover, Lordship, this is a defect. They can, their counterclaim will be rejected. They can cure it and file it again. They will get benefit of section 14 of the Limitation Act, everything they will get. But this counterclaim as it stands now, Lordship, cannot be made. That is at another 60.
I am obliged, we are obliged, my lord, heard us, my lord. My lord, there was one beautiful point arising out of this, which was not occasion, because the dispute was on the international law. And in the international law, when the proper law of the country is not there, which is called subjective law governing the subject, then the international law applies. Because here we have not agreed that the Indian law will be applicable. No one has agreed. International law will become applicable. International law says that person who has available in the country, that country has a jurisdiction. And this, well, that is, I said I don't know, but there. I was not needed. It was not needed, but it was also a interesting point on this. It was not needed in this case because this was not raised anywhere, but yes, yes, yes. No, but we are deeply obliged, man. This.
Number 7.
The problem is the after the operation, what are the steps? Your lord, 4 or 5 operation motion. That will be called up. Otherwise, the operation motion is not possible of time. Your country has to decide. I do not know what it is, but I have to decide on it. And I have decided on it. If you are clear of this, that I want to they will have some find them or nobody done. Other service order. All advocate of the trial court. So that I can pick up the advocate of the trial court. Trial court has served the copy of the petition. No, no. Now I said communicate the item number 8.
Well, at 8 minutes before my learned friend starts, Lord, what happened, my lord? Well, before my learned friend starts, my lord,
item number eight. I appear for the opposite party number 1. I feel caveat was there. What happened? This is a proceedings under the Cooperative Act for expulsion of a member. That proceedings has been initiated. That has attained finality. That order has been challenged before this honorable court in writ jurisdiction. Now that is pending. Now here we have the expulsion of that expulsion of a cooperative member was the consideration. No, they are not corrupt, sir. They have challenged that order before this honorable court in a writ jurisdiction. That is pending. That is pending. Now, the society, cooperative society has gone before the civil court, to execute that order. In that execution case, they have applied under section 47. That order is under challenge over here. Now, what happened? That committee has lapsed. That committee is not there. New committee has come. I have instruction from the previous committee. So, today, yes, that is what I am saying, because they have served upon me, they have intimated me by way of an email. That is why I am refused to receive the notice. Yes, that is why I am intimating to my lord. Because there was a caveat. Today I have no instruction to it. That I live.
Rejected on the ground, my lord, the order was passed under the Arbitration and Conciliation Act and executable by a civil court. Whereas there was no such order, there was no such process. May I submit, my lord? Oh, West Bengal Cooperative Society Act is special. There are special provisions. Civil court jurisdiction is out. And any dispute concerning the business and affairs of the cooperative society is to be referred to the registrar for arbitration under the not under the Arbitration Conciliation Act, under the West Bengal Cooperative Society. And those proceedings will be registered as a dispute case.
But I have instructed yesterday, I
Tomorrow is the date fix of the execution case for police. And there is yes.
But after 10 days.
Yes.
22nd.
Today, the execution case cannot proceed.
The execution case is not at all mentionable. That is our yes.
Let me take it.
Item number 9.
I am for the opposite party number 4.
Application. Sir, application ongoing because they are about 13. Only on the ground. Comes to a finding that they've been absolutely for nothing. No, but putting in the money in terms of 17. 17. So even if your lordship goes under to AB, 13 years without any reason saying that I did not taken anything would not have been done. And what happens here? 72. 72 is no. The suit blood today, if this is allowed, then my suit goes. Honorable provided that he complies with 72. Here he has not. As a hospital. 17 2 when he goes up, he 10 at that point of time, he gets that opportunity, which is after 17 4. 17 2, right. That is at the time of 17 2. So degree is passed, or rather the suit is dismissed, saying that he's got an opportunity under 17 4 and first default. That's first default. And then when he makes another default then he doesn't get that opportunity with 17. Now what has happened here, he has not complied with 17 2, but he is now being followed after 13 years, saying that this is the money. That cannot be done. Property
APC Road. North Calcutta.
One go down, 2 rooms, 1 and 2 except the mezzanine floor at 243 bottom 1200 and it's about 1270 square. 8 is and tell your lordship. Oh,
500 now.
And that too he will not pay. And that too, because this is a suit of 75. This is a suit of 75. And the court says that I will use discretion in his favor. Unheard of. And what happens is, by this what happens is that my suit is getting dismissed because he will get an opportunity, 17 4.
But I am always ready.
But he's fixing, the learned judge has on me a cost of 5,000 rupees because my learned senior friend has gone and said that but there is no stay, why can't you hear? 5,000 rupees, I fail to understand what's. Hey, I am to get money from him. I am my property he is enjoying, and I am going to pay 5,000 rupees. It's unimaginable.
But every bit of money has already been deposited with
After 15
interest,
years, 20
with,
years, you have
with
deposited.
penal interest. My client was suffering from cancer. But I shall.
Commercial.
No. But commercial, there is nothing basically.
There is
No
nothing.
business. But yes. But no business since long.
Then why does he have to occupy it? Leave it.
But let them come to a compromise with us. But very well, but we shall. That is no problem.
Last one is 13 years, my lord. 75, he has not paid anything. The last default is 13 years.
But my High Court has also given relief to my clients. There was a stay for a period of maybe 15 years. Well, but yes. But business is not good.
At the present moment, it has been bad for, yes, it is bad for several years. But if the client, but if, absolutely, Malad. Very well. Very well. But if Mr. Chatterjee's client,
Milord, let them not 5,000 rupees I have been asked to Milord, can you, my
stakeholders,
suit,
yes.
I am paying.
but states, but we are not standing in the way.
Milord, can you records that? The record.
But we are not standing in the way of grant of a stay, Milord.
Obviously, you will not. You their suit. If I was in his position, I would have. Milord, can you fixes a date, Milord, any day your lordship pleases?
Absolutely possible, Milord. তোমাকে বলবো একটু জায়গা দিতে হবে draft of yes, we have exchanged drafts also.
Of the agreement was exchanged.
And also they will not insist on that 5,000.
Ejectment suit.
Ejectment suit number 2012 or 12,000.
2012 or 2000.
Lordship has observed that settlement proposals. Lordship.
Deeply.
My lord has been reasonable in settlement. Any day, your lordship. Milord, I will take only 7. 7 days maximum. Because I am told now, my lord, I am told now they did not proceed with the settlement. They gave a draft, but then they said no.
My lord, rent has been paid. The increased amount was before.
I will be. My client is here. I'll definitely. Whatever, let them come up with that. Your lordship may also not.
Not a, but it was not a commercial property. But apart from, yes, yes.
And he's given us that. Third February?
No, no, অত তাড়াতাড়ি করিস নি second week কর second week. Yes.
I'm just after Saraswati. No, just after Saraswati Puja. Fourth and fifth, third, fourth. Fifth is a very auspicious day, not your lordship. And 14th is an even more auspicious.
The 14th third.
Thank God your lordship did not do that. 14th.
14th.
Lordship, I'm not for the petitioner. I'm for the opposite party. I've already written to the advocate on record for a copy of the petition, my lord, because this is a highly contested matter. We have also filed another revision. Lordship, no caveat was there because we see the cause list every day, my lord. My lord, after my lord hears the matter, my lord will find it that I have a right of audience. Oblige, my lord. Lordship, I am also under the weather. Thank you, my lord.
My lord, let it be fixed tomorrow.
A copy, you,
My lord, I'm challenging the execute order dated 11th of. No, my lord, it's a remote application. A written statement was filed after a delay of 197 days, my lord, without any affidavit, without any verification, without compliance of order section. My lord, that was in the ex parte court. My lord, the written statement. Absolutely, my lord, I completely concur.
they have a child together. Lordship already filed, my lord. Already filed. This is, that is why I'm saying that this is a.
My lord, in the certified copy.
Lordship, the wife, and I have a kid, my lord, who is present. Do not. Lordship, because. Lordship, I'll.
My lord, the written statement, once your lordship delivers the file, your lordship.
Lordship, there in a undue hurry.
Without a single signature.
Lordship, their copy. Lordship, may a copy be served upon me, my lord, because.
My lord, kindly peruse the written statement. Just for one.
Tada. Lordship, kindly do not do. Sorry.
One of the court has been applied for the favor to the king. My lord, that would be extremely kind of your lordship. Absolutely.
Lordship, two, three things, my lord. I want to say something. If
Kindly, Your Lordship.
I need a copy of the petition, my lord. Lordship, I have something to say after he finishes. Sorry, my lord. I will.
My lord, 12,000 rupees per month towards the child with the paid. The wife is a BDS, a dentist. That is why her maintenance was not allowed. They have come for that's a separate matter. This matter, my lord, the written statement. It is not. There is not a single signature, man. Not even for the advocate, not even for the client. No verification. My lord, they had enough opportunity after 197 days. They filed.
Lordship, that.
Yes, my lord. Yes. Yes, ma'am. My lord, I earn 40,000, 12,000 rupees I'm paying for the child every month, month on month. That I'm doing, ma'am. I've done everything possible.
Lordship.
My lord, let the matter be kept pending for till Monday in the same position. Mr. Banerjee will come and submit it.
Lordship,
In that
then
same position, my lord, it will-
can I take the petition, my lord? I will. বড়া কোনো কথা বলবি না। Lordship. Miss Debolina Ganguly.
He does not have power.
Lordship, I will. In course of the day. Lordship, kindly, if my lord can keeps it tomorrow, I'll file it tomorrow. I have the wakalatnama signed this week.
My lord, one small interest. My lord. What is the signature? And the and the and the notarial certificate. Nothing is.
Lordship,
So it was paid. It was supposed to be paid to the secretary ALS. As per the.
Lordship, do not do that, my lord. Lordship, I'll tell you, Lordship, Lordship, there are few things, my lord. Kindly gives me one opportunity of hearing. Lordship, it was not done belatedly. I will prove that to your lordship. It was not done belatedly. It was not done without signature, my lord. We have served them an advance copy. Lordship, may I say something, my lord? One. ঠিক আছে
Item number 11.
Lord, the plaintiff, Lord, is the petitioner before your lordship, Lord. In a suit for, Lord, recovery of money, suit is, Lord, under Order 37, commercial suit. Order 37, commercial suit.
Upgraded.
My Lord,
Upgraded.
upgraded, yes.
Why?
Lord, the urgency is, Lord, I am today entitled to the decree.
For that upgraded, sir.
Lord, the business is suffering, Lord, immensely. We are, Lord, a small scale, Lord, carrying on business on a very small scale basis. Those funds are utilized in
Commercial
our
court.
business. Commercial court, Alipur. Your
Refused
lordship
to
knows,
pass.
Lord, first day,
Refused to pass.
my lord,
Refused to pass.
did proceeding as if a regular suit is being proceeded with. You file appearance, date for appearance, thereafter parties file wakalatnama, next date you go and file SRAD, thereafter written statement. I tried to, Lord, reason out, but Lord, I failed. Recent order has been passed, my lord. This is the second order after my arguments were there. Kindly have a look at. First of all, commercial suit. Thereafter, my lord, order 37 suit.
It's fixed for hearing. I will not. It's fixed for hearing.
Lord, I say,
IA is fixed for hearing.
Lord, I say,
I'll keep it pending, Mr. Kormokar.
Lord, what I say.
I'm not dismissing this, Mr. Kormokar. I'm keeping it pending. If it is disposed of whatever way.
May I just indicate once? I'll not take your lordship's much time. I'll amend it.
Fixed on this date.
Lord, this application is not even required to be heard by the others.
Maybe, but he has been, now the court has everything, Mr. Kormokar, if I try to enforce, you see,
these are procedural irregularities.
Certain discretion has to be given to the learned judge who is doing it in the ground reality. The 1st of February, Mr. Kormokar, 1st of February.
I have filed a suit on 30th of September.
Nothing happens on
2024.
this date, you come back. I'll keep this pending. Matter pending after first.
Lord, then kindly makes it returnable on, Lord.
After first. After first.
Not in the monthly list, Lord. After first.
No, it's always in the monthly list with that. I'll place it. Group 1, motion 1.
Very well.
এই মোশন ওয়ানে কতগুলো আছে? এটা তো তলায় আসবে না 18। মোশন ওয়ানেও তো অনেক তলায় আসবে না? হ্যাঁ, তাও তলায় আসবে না? Having regard to the fact, at line.
26th.
Mr. Kormokar, learned advocate, convenience. The learned judge is
Fixed for decree, then
learned judge is entitled to do that.
it ought to have been fixed for decree in that
I
case.
little bit here and there. Let it go on the next date. If it doesn't happen, you are there again. Then on February, everything will be over.
ঠিক আছে।
আর না 26 তারিখে অনেক দেরি করে দিয়েছে, আরেক সপ্তাহ আগে করে দাও। দাও সব আগে করলে সে 20 পড়ে যাচ্ছে।
Lord, I beseech your lordship, Lord. Second week of February, my lord, in that
19
case.
19 করে দাও।
ঠিক আছে, তাই পাওয়া গেল। ঠিক আছে।
1st February দেখো ওই তো নর্মাল যা হেডিং এই থাক, ডেট থাকবে, যে হেডিং এই থাক, মোশন আন্ডার দি হেডিং মোশন, মোশন 1, নিউ মোশন 1। Call the list.
Make please, your lordship. Well, this is a very
Urgency,
small-
sir. Upgraded.
The same matter, sir, where the tenant who failed to comply with the provision of 17(1)(a), Lord, 1956 Act. There was a direction of
1956.
Tenant to deposit the monthly rent on the, he defaulted. He made an application for condoning that default and to allow him to make the deposit.
Only
Learned
5
court
days
below
delay,
the
my
learned
lord. It's
court
by
below-
application, sir. Let me
my
tell.
lord,
It's only a 5 days delay. 313 months I have paid in time. For the month of May 2024, there was a 5 days delay, and that was delayed because my lord, lordship is quite aware of the reported judgment reported in 2019, volume 10, Supreme Court cases 660. My lord, in the old act, there is a provision that one can give. My lord will kindly see the judgment. And that was exactly recorded in the first order.
This suit is 25 years old. 25 years have passed and we are at the stage of, my lord, evidence, my lord. We are at the stage of evidence. Now, because of this revision application, the suit has already go 3-4 months.
My lord, what
Yeah,
happened?
because of this
My lord,
development.
at least 5 persons died in the meantime, both from the plaintiff side as well as the defendant side. So what we'll do?
He wants to
There is a
deposit the rent. He wants to deposit the rent. My lord, depositing the rent will not, my lord, there's an issue before the trial court, whether he is a defaulter or not, my lord, that will be decided at the time of the argument, whether he is a defaulter. If we
No.
17-2, that defense he has. Defaulter defense goes once he makes payment.
17 is not a final finding.
Yes.
Your lordship knows that. It will be, there's an issue, that issue has to be dealt at the time of the argument for
Where you have your old act? You have an old act?
Yes, my lord, I got it.
Because
Hey, a consistency act দাও, old act।
trial court will have to.
56 সালের act দাও।
My lord, may I read out?
issue of default. That issue is there, whether he is a
I
defaulter or
I
not.
brought that especially, my lord, the old act. I'm covered.
Read 17-2 and
Yes,
17-4.
my lord, 17.
Read 17-4.
4, yes, my lord. 17-4.
Read.
If a tenant makes a deposit
নেই এখানে।
or payment as required by subsection 1, subsection 2 or subsection 2A, no decree or order for delivery or possession of the premises to the landlord on the ground of default. In payment of rent by the tenant shall be made by the court, but the court may allow such costs as may deem fit to the landlord, provided that a tenant shall not be entitled to any relief under this subsection if the same. My lord,
I read it, sir. Why are you stopping?
Lordship. That subsection, if having obtained such relief once in respect of the premises, he has again made default for the payment of the rent for 4 months within a period of 12 months. But my case is only 5 days. So I am covered, my lord, with the judgment.
All I am saying, my lord, I am concerned with my suit.
My learned friend is allowing practical.
Disposed of, my lord, my suit will start now. That is my only.
I'll dispose it of here and now.
Lordship.
Dispose it.
What is the order?
My lord, order is annexed, that order dated.
Only on the ground of default.
No, there is a
Reasonable requirement.
requirement. That is
He
why I am-
survives. His suit survives.
My lord,
And-
12th of July 2024.
and another cause of action of the accrued, my lord, the tenant has recently died, my lord, that 5 years period has expired.
So how can that be?
So he has died.
How is the old act, my lord?
Not before the enactment of the act.
You remember, Justice Banerjee passed an order that is supporting you. But recently, the Honorable Supreme Court made certain observations in a matter. Where is that judgment? Where is
The
it?
judgment is that, my lord, if the tenant has died.
I have not read it. I have a copy of that judgment.
At present, I don't have that judgment, my lord, but I can provide it. But that is not the ground over there.
Leave
My
about
lord.
judgment, my lord. My learned friend is doing the matter without any brief.
No, because I want this application to be disposed of, because my suit will start. Already 20.
I'm not on that, my
No, you
lord.
are agreeable. Then I will not pass a judgment. Not necessary for the court.
I'm not.
No, you tell you are taking instructions from your client. You can't. You take instructions from your client.
Uh,
Accept. Yes. And you are aware the law is clear on this subject.
I will.
Why was it rejected? Why? What the court said?
She did not allow it because.
My lord, it's not only allowed, so many, if my lord will see the order, my lord will understand. So even this judgment is being observed. But even I don't want to make any submission.
No, don't. You should not.
I should not.
You should
My
not.
lord.
Please
But
understand
if my
this.
lord, if my
Or
lord
you should
reads
know
it,
where to submit and when
yes,
not
where
to submit.
it. But if my lord reads it, because
Show me which paragraph.
my lord, this was rejected and all the judgments were relied upon.
This
Lastly-
CO 1385. Where is this?
What's it?
CO 1385. Where is this judgment?
CO 1385. 1639 is the ejectment suit. CO.
CO 1385.
No, this was I have not given. I have not given this.
The learned judge.
Learned judge has out of her own.
I want to know whether it is a new act or old act.
Old act.
93. The suit has.
Admittedly. Old
Oh, the judgment.
CO 1385. Old act or new act?
New act, my lord. 7.
All Nasiruddin, all new act. You are appearing for?
Similar matter is there.
You are appearing for?
I have prepared a revision.
You are appearing in this matter. Please don't make submissions, madam. No, please don't make submissions, madam.
My lord will allow me to deposit for the month of May and thereafter subsequent month.
You show me these judgments. What are these judgments?
These judgments, my lord, I am covered by this judgment.
Please understand, a learned judge has considered these judgments. Without looking at these judgments, I'll pass an order. Please understand, it was your duty to bring these judgments.
Because, my lord, even this judgment was relied upon. But since my lord, the learned court has
Please understand the situation.
overlooked this judgment.
I will ignore a judgment passed by the learned court without going through the same. What are you saying? The learned court has taken pain to write down a judgment.
My lord
It is
will
my
come-
duty
my
to
lord will
look
once
into that.
come to the page 2.
Come back tomorrow.
Yes,
I'll come back
sir,
to
you understand all the copies. So you see, I don't know what the learned judge has considered. She has rejected the matter.
Lordship had to deal with
I will, yes, I have to deal with the same. Unless you say by consent, I can set it aside. No, you can by consent, I can set aside. But still, the learned judge has passed an order.
ये judgment है by consent कर
हाँ?
दो, delay होगा फिर.
Yeah. No, we are coming back tomorrow.
I'll
My
not
lord,
tomorrow. I'll
tomorrow is
place it
not
next week.
possible for me.
Next week.
Because,
Same,
my lord,
same.
today was my daily matter. I have to cancel that especially
Here you
because of this matter. my
Next
lord.
week, I'm placing it.
Lordship,
Next week,
next week, not on 15th. I'm
16th, 17th, 16th, 16th,
16, my lord.
16th, এই 16th এ মামলা আছে আর একটাই আছে তো, এটা তো হিয়ারিং মামলা। Having heard the learned advocates appearing for the prospective parties, now the view. You bring all from that judgment, you find out, because I have to consider. Learned judge has passed an order.
There are, I should not be saying.
Maybe it is on 7-2, maybe on 7-2, maybe, but still then I have to go without looking at it. Can I ignore it? Yes,
My
that's it.
consent करा दो फिर
अरे आप नहीं समझ रहे हैं आप consent बात का बात नहीं I have to consider this.
So if it is by consent, my
I can
lord,
set it aside, but it is not fair that way on the learned judge. Not fair on the part.
because my lord, even this judgment was considered was
Let us not, you do not make any aspersions.
I'm not making it.
Please don't.
I'm not.
Well,
Because
matter
my
is
lord,
there.
the
I will allow the application after hearing this. Wait, sir. Let me go through what is written there. Yes. Call the next matter.
Get consent for suit.
I understand. On that date, I'll allow it.
Get me.
You bring Miss Sam and you bring those all these orders. You have to deal with them, all of them. Yes, where is Mr. Haldar? Where is Mr. Haldar?
I'm from the opposite party. And lots of submit that. The application for amendment had filed after the petitioner had already completed the argument. We also submitted no opportunity or the petitioner filed an additional written statement as well. The lordship, I have got the certified copy. They have filed the additional written statement on 19 November 2004. And that opportunity given by this learned tribunal on court that 22nd November 2024. So this is the certified copy.
This has been allowed belatedly.
Yes.
Amendment has been allowed belatedly. You are not disputing that.
No, I have disclosed everything. And last occasion, they have
Well-
submitted that they have not they have not given me opportunity.
That is different. Very well. Where is your amendment? When was the amendment allowed? After the arguments were complete.
Yes, Lord.
Then
And the judge was allowed that.
a learned judge has allowed it, but why will the learned judge allow it? After everything is over?
And the cost was imposed.
Now, this commissioner's report was there.
Many judges.
Please understand, the commissioner's report is not a new fact. So you are trying to take advantage of the argument of the other side.
Lordship,
You cannot be permitted. You see, sir, can you be permitted to rectify a defect in the pleadings on the basis of the arguments made by the other side? Please understand and tell me. Mr. Haldar is not here, I know that, but I will not dismiss it on that ground. I have admitted it. You tell me. He will join in. You tell me. Once, you see, once it is very difficult to admit, but once I admit it, then I'll hear the matter.
I have just instructed from my senior.
Who is your senior?
Mr. Shivaji Kumar Das.
Where is Mr. Das?
He is in court number 28, maybe. Just he comes.
যাক পরের দিন থাক যাও নেক্সট ডে আজ কি রিটার্নেবল মোশনে আছে কিসে আছে
Lordship,
এটা দিয়ে
judgment was fixed by this learned court. That
when you I'm placing it. Mr. Das will be here when? Tell me Monday, Tuesday, Wednesday দিয়ে দিচ্ছি বুধবার when you want it, tell me. Wednesday, I'll place it on Wednesday.
difficult for me. Tomorrow,
Tomorrow I don't take up. Wednesday is difficult. I'll mark the list of March.
Lordship, the judgment,
Then
trial court was fixed on 6th February for judgment. Lordship.
I've stayed. How can he fix for judgment? I've stayed everything. His judgment will not come unless I decide this matter, sir.
Stay only for month. List of January. Lordship.
Yes.
Lordship,
Mr. Das, I'm placing it on next
What
Wednesday.
has happened here is
Next
entire
Wednesday. Next Wednesday.
petition has been stated.
Next Wednesday, I'm placing it. Mr. Haldar is also not here. You were also not here. So I'm since I accommodate both, I'll place it on Wednesday and take it up. He says that it should not be extended till next Wednesday.
Kindly, because my lord, they have.
I'll
submitted
place it
that-
on next Wednesday. Come on next Wednesday. He's not Mr. Haldar is not there.
But-
List this matter on Wednesday. Date দিয়ে দাও. না লিস্ট নয় let this matter be taken up for further consideration under the same heading. On Wednesday, কটা মামলা আছে? কটা মামলা আছে? ছটা, ঠিক আছে। Under the same heading, on Wednesday, date দাও. The interim order shall continue till the next date of hearing. The interim order passed.
31st of January.
Oh, it is there. Oh, not necessary purpose. I will dispose it up on the next date.
But they have suppressed it.
Both of you were not there. Mr. Das, you were not there. Mr. Haldar is not there. He is saying that no, it should not be adjourned. Then I'll adjourn it the next month. The object is to ensure presence of both. And thereafter, whatever, where the matter goes, matter. Yes, once I admit these matters, Mr. Das, then I do not dismiss on.
But may I make one claim?
Yes.
Wednesday, in the supplementary list.
No, it is same position. It will be taken up. 6 matters are there. 6 matters is not a very big deal. Generally, fixed matters, Mr. Das, are taken up. Generally, up to now, this court has not missed out, but you may not have appeared because of your resolution of the sort. But
No matter what, I have to appear because what has happened is the evictions.
come on that date.
Aisha.
Dako, পরেরটা ডাকো।
I know this is my revision application.
Yes. Why are you interjecting when another matter is going on, madam? That is not your matter.
I'm sorry.
You should not interject, try to intervene in another matter.
I'm sorry.
Yes, what is your matter, madam?
My lord, in 2020, an eviction suit was filed against me.
2020, eviction suit was filed. Yes, fair enough. Then
Yes.
what happened?
And on 24th November 2021, I filed applications under section 7.1 and 7.2 of the West Bengal Premises Tenancy Act 1997.
When was the suit filed?
2020.
And when did you file your 7172?
24th November 2021. These were allowed.
COVID protocol. Very well. Then
The applications were allowed. And since then, I am depositing the rent. I was
then
repositing.
what are you aggrieved?
My lord, I have deposited the rent to the credit of the suit till August 2023. In September and October, my clerk defaulted in payment of rent. I paid to the client paid to my clerk the rent, but my clerk defaulted in payment of the rent. So when in December, my clerk went to deposit the rent for the month of November. The department refused to accept the rent for the month of November 2023. And so I preferred an application before the learned trial judge to direct the concerned department to allow requisite rent.
What is your previous order filed passed under section 7.2? Yes, sir. Madam. Is there any previous order under 7.2?
Even to my lord, allowed.
Where is that order? You will not annex orders. What do you think? You want an urgent hearing of matters? What is this going on, madam?
Madam, it is my fault, sir. Your
Choth, Vikar.
On next, I will bring it.
Admittedly, it was allowed.
I want to see that order. You understand why? You understand why, Mr. Bhattacharya? Can you bring that order? Can you bring that order? Because I am not sure she can bring the order. Because I have admitted the petition, now I cannot reject it just like that. Yes.
Compliance of 7 months.
No, whatever. I have to read that order. Without reading that order, how can I? Why don't you annex these petitions, madam? You come before the High Court to file applications. Agree from each and every order you come to the High Court.
No, I am.
I am finding it difficult to place these matters. Because the list is full. You see, it's very difficult to place a matter.
I am aggrieved due to the order dated 13th February.
Whatever you are aggrieved, you remain aggrieved.
2024.
This is post 7.
The petitioner is unable to produce the order passed under section 7.2. is unable to produce the you have a copy with you. You have a copy now. Because difficulty is, you see, to place these matters again in the list, because these slots have been all, if these slots are filled up unnecessarily, I cannot take up new matters. Yes, naturally. Yes.
Monthly.
Yes, sir.
Lordship, last
5th February, madam.
yesterday, Lordship, you had asked a senior friend to whether his client accepted the rent or not.
Just remind me, sir. I just.
Lordship, fact is that, Lordship, my client being plaintiff filed a suit for declaration that I am the bona fide tenant without due process of law cannot be evicted. Thereafter, my client also filed an application for injunction. Injunction was allowed.
Oh, you have not determined the relationship, Mr. Ghosh.
Lordship.
Yes.
Thereafter, I filed an application for 151 paying for repairing of the certain portion, and also filed an application for local inspection order 39 rule 7 to extent of the
Your
repairing
local
work.
inspection has been rejected. On the
Rejected,
ground and you are not paying rent.
paying it. Already I was showing that
You will accept
rent
rent.
receipt.
No, whatever you submit. You submit. Yes. You sit down.
Transfer the property by execution of the registered deed in favor of my client. That is not different number 2 entry. That is date is 8th November 2019. Lord, your Lordship, you will see that he said, I am a tenant under this Obisek who was not asked by owner and landlord. And Lord, kindly see this suit was filed on
Who transferred? Abhishek Das transfer
Obisek Das transfer
in your favor.
in our
Then you issued the letter of atonement. He did not make any payment to you.
definition of landlord in the Provincial Tenancy Act, who is at present entitled to rent. He has not done it. No, rather, he has annexed some rent control challenge of 2020 in favor of Obisek. And Lord, he has made us party.
That is why I am saying, Mr. Ghosh, that he now acknowledges you are the landlord. And you have today, up to this date, not determined his relationship. If you determine his relationship, it will be post this date.
That is already if I do not want to evict him.
Correct.
Tenancy, so far tenancy is concerned. It started, it is continuing. So the landlord has transferred his interest, his tenancy is unaffected. He just will pay me rent.
That's why I'm asking you. The offer is there. You may accept, you may not. There is no compulsion. Yes.
That now I am entitled to rent.
Yes.
In spite of that, after transfer, when he filed the suit, in paying paragraph 1, he said that I am a tenant of the Obisek Das and I am paying rent. And rent has been deposited from 20. Suit has been filed.
No, wrongly translated.
You sit down, sir. The senior is making arguments.
Yes,
Please sit down, sir.
kindly.
Let him submit, sir. I will hear you, sir, later.
Page 12.
You don't make running commentary, sir. This is not expected, sir, in High Court, sir. Oh, yes, sir.
First channel is at page 11. Dilip Sahu was the estate of Panchanan Das represented by Opisek sir. Not second column, third column, second column. Third column.
Seen there.
There's no kind of date when it is 11, 12, November 2020.
He's not a good person. He's a bad person.
That is, I'm not saying not anything, whether good, bad, or whatever.
No, he's a bad person. I accept the fact.
Says in pen.
But you, Mr. Ghosh, tell me, can you disentitle him from the share repair? That is something else. Yes, yes.
That if I accept you as tenant,
Yes.
you pay me rent.
Yes.
Let him pay me rent up to date.
Yes, yes. Certainly, sir.
Yes.
Sir, goes without saying, sir. Once I do that, the entire amount is paid, and thereafter I will pass further orders.
It's not from the date of purchase, they are entitled to. Let him pay us.
Lordship, kindly see the.
No, are you ready and willing?
Yes, yes, Lordship, up to payment of the rent control, thereafter I pay.
Yes, yes, show me.
Lordship, kindly see the page 12.
Page
Page 12, Lordship.
No, how, according to you, you tell me, according to you.
Yeah, till date, my client paid the rent control, before the rent control.
Rent control will not. Now needs no one. When they have purchased the property?
So that is from 8th of November 2019.
2019, from the date of purchase. Then intimation given when?
The intimation given on 23rd December 2019.
Is they admitted? Did you receive intimation? No.
But he has accepted and brought that.
Show me, yes. Then I'll pass an order to that effect.
No, kindly see, this is the
Yeah, thou. You can't have both. Two sides you cannot have. One you. Letter is there.
What is
So, all this. Which place? Shao, place. Garden Reach. Bharati Shao. Garden Reach. এই ওনাকে দেখতে দাও ওনাকে দাও you after you go through this, hand over to Mr. Ghosh. Take instructions.
the number? Where is he? Delivery confirmed on 7/1.
From this date you pay.
Yes, Lordship, my client already deposited the rent. But then
letter of adjournment is there.
Then Lordship pass the appropriate order to withdraw that amount from the rent control.
Yes, I'll grant you leave.
Otherwise, I can.
You take instructions where are you ready and willing to pay. If you
Yes,
are
I am ready to pay.
You bring the entire check amount, I will pass an order in your favor and dispose it of granting you liberty to withdraw.
Without withdrawal that amount, I cannot issue the check, Lordship.
No. Then everything will be kept pending.
Lordship, also another thing, Lordship.
No, sir, if you pay today, I'll grant you leave provided this Abhishek is party. Yes, Abhishek is party.
Yes.
So I'll grant you leave. Yes, I'll grant you leave to withdraw.
Yes, then I withdraw that amount and then also pay.
No. First you pay, then you withdraw.
From 2019, Lordship.
Sir.
Lordship, they not file any suit at all. He not counterclaim at all.
You make up your mind what you're going to do.
Lordship, my client must.
Yes, take instructions and come back. Otherwise, the consequences will follow.
My
tomorrow, not today only. This no, kalke ki bar?
Friday,
Monday. So effectively, not today. Mr. Ghosh, it will be there in the list effectively. Means only not today.
Just say same word as my lord.
Kindly give him a copy of that document. Yes, letter and that enclosures everything. Kindly give him a copy. And you see, sir, I'm very clear in what I propose to do. I do not hold back myself. So you get a clear picture. Other sides get a clear picture what I propose to do. You pay this amount. Abhishek is a party. I'll grant you leave to withdraw the entire amount. You will withdraw it. Minus the commission. Some commission you cannot withdraw. Entire amount you cannot withdraw. Maybe some commission is held. No, I'm telling you, Mr. Ghosh, he cannot withdraw the entire amount. Some commission perhaps is retained. And an entire amount. Fair enough. Oh, very well. So you withdraw that amount and I'll allow the commission. I'll allow the commission. And on the basis of the commission, if you succeed, then is your.
Then loss you.
That you understand.
Loss.
I'm
Yes.
not going to grant you that order. I mean,
No,
very
no, no.
clear. What is the.
How can loss
So
pass?
what is the modus of operandi in passing, how the matter will proceed? I've indicated. Now, whatever instructions you have, you bring it on that next day. Consider and come back Monday. এই এটা হচ্ছে না, এই আগেরটা অ্যাডিশনাল রিটেন স্টেটমেন্ট দিয়েছিল না, এটা বাদ চলে গেল ওই আগেরটা, ওই যে এর আগের নাম্বার যেটা ছিল, you take instructions and come back. Some you win, some you lose. You have to take it with your stride.
Without filing any suit?
Yes, sir. Some you lose, some you win, some you lose. You also cannot take advantage of your own wrong. After all, you are before the court of equity. It's called the next matter. No, this is not not a civil application. You are exercising jurisdiction under Article 226.
227.
227. So it's a constitutional jurisdiction. So the court is entitled to pass appropriate orders, what it thinks necessary in the facts of the case. Yes, call the next matter.
Yes, my lord. I am appearing for the petitioner committee. I have come before your lordship against the order passed on April 2020.
Passed on?
1st February 2024. Allowing the order 6 rule 17 petition. And it is the suit for recovery of possession from ex-licensee. It was the suit for recovery of possession from the ex-licensee. And thereafter, he filed the written statement in the year 2022. Thereafter, he filed the petition in the year 2023, Order 6 Rule 17. And that Order 6 Rule 17, I have specifically stated that the nature of defense will be changed. The opposite party filed the Order 6 Rule 17. And it will surely change the nature of character of defense of the, it will alter. And accordingly, the order is.
Sir, can he file an additional written statement instead of amendment?
No, sir. I am.
Please tell me this.
No, I am not.
Sir, he is not the plaintiff.
I am petitioner plaintiff.
Correct.
And that.
So he is putting up a defense.
He is putting up a defense. New.
Is he trying new case? So he can put. Is he trying to put a case where he seeks to withdraw his admission? You cannot put a new case.
No.
You cannot. But
not change,
such a rigor is not applicable so far as WS is concerned.
Yes, WS is.
WS court will not look into the fact whether it changed the nature and character of the defense. Nature and character of the suit, not the defense. Please mind the language.
Yes, sir.
Nature and character of the suit, not the defense. Because ordinarily, under the provisions of Code of Civil Procedure,
Yes,
the defendant is permitted to file additional written statement.
Yes, defendant has filed the additional written statement, but he has filed the Order 6 Rule 17.
So that rigors,
some new
strict
facts,
rigors
sir.
will not apply. Strict rigors will not apply. Show me judgments that it should apply.
Whether he can file the.
He can always file amendment. Everyone can file.
Everyone file an amendment.
But
that can be
simply
filed at
because
any time.
the
After
nature and
15 after
character of his defense changes, he will be precluded from putting forward the same. There is a marked distinction between amendment of a plaint and an amendment of a written statement. Come to the Code of Civil Procedure. Hey, boita dao na. Yes, sir.
It is, sir, under Easement Act. The petition is filed under Easement.
Whatever, that is a defense. He's setting up a defense.
Yes. You show
If
the,
you are trying to make a suit claiming you are a leave-in license, and thereafter you change it to landlord tenancy, or from landlord tenancy you change it to leave-in license, that will change the nature and character of the suit.
yes, here it
But
is happen-
if
it is
he
happening
sets
here.
up a defense that initially he is a tenant, subsequently he says I'm a licensee, you can say at best he is trying to withdraw his admission, which is not permitted in law.
Yes, my lord.
Show me that it is akin to withdrawing of admission.
My lord, when anyone person files an Order 6 Rule 17 petition, why is the delay? He has not mentioned this. Not only that, he has not annexed any paper showing his rightness in the Order 6 Rule 17 petition. And at belated stage, he has filed this petition, Order 6 Rule 17 petition, when the petition under 7.2 is pending.
Yes.
At this latter stage. And not only even that, he has not mentioned why he is delaying this. What is the
Come
cause
to
of-
Order 8, Rule 8. Come to Order 8, Rule 8. Please place Order 8, Rule 8. Place it.
Thank you, thank you.
Yes, place it.
Sir, sorry, Order 7. Order 8, Rule 8. 1 minute, sir.
Yes, yes.
New ground of defense. Any ground of defense which has arisen after the institution of the suit or presentation of a written statement claiming a set-off or counter claim may be raised by the defendant or plaintiff as the case may be in his written statement. Yes, sir. But here what is happening, my lord? Any ground of defense which has arisen after the institution of the suit, or the presentation of a written statement. Then after written statement or after institution
It is
of
only confined to Order 1, Rule 8. Order 8, Rule 8.
Yes, my lord. I mean, that is only
Now, apart from, so therefore, the regards of Order 6, Rule 17 do not apply.
Could not?
Regards of amendment of a plaint under Order 6, Rule 17 do not apply. Come to Order 6, Rule 8.
I have not filed. I am the
Naturally.
I have not filed Order 6 Rule 17.
He has filed it. Correct?
Yes, filed it.
I understand, sir. You are agreed by the allowing. Well, what is the written statement? Let me find out.
Consequential order, you will.
Let me
will
find
pass.
out. Written objection you have given. Where is the what?
Yes,
was the-
I am showing. Written statement. Page 30. Written Order 6 Rule 17. Written statement. Page 18. Page 18. Yes, sir.
So what is wrong? 13A, B, C, D. Why? Why are you agreed by this?
What he has written in the Order 6 Rule
Schedule
17.
proposed amendment. Yes.
Here he is written that it was the tenant, he was a tenant. And for the month of paying rent regularly. Then subsequently it has enhanced 1,500 per month. That on receipt of that all is written.
Where is written statement? Where is his written statement?
Yes, my lord. Page 19. Please, page 18 written statement. Please look into this page 19, my lord.
Yes.
But everything is written there. No new facts. No new facts has been added in the Order 6 Rule 17 petition. It is already written in the written statement.
So according to you, nothing new has come in the written statement.
Yes, my lord. In the amendment.
Then why are you objecting?
Yes, I am objecting this because if it is already written and he has filed this petition, which is already in the written statement, and he has filed this to show the consequence for the consequential order.
Yes.
That is the reason I am opposing this. And not only that, the learned court below has not given any reason why he is allowing this part. On the other hand,
I will give that reasons.
Okay,
For the purpose of determining the real question of controversy in the parties and for elucidating what is already there. Since you say that this is already there, so
I understand, my lord, but it is the fact he is trying to bring another way on the under order 6 rules, which will affect the consequential order of the matter.
What? Show me that. You could not up to now show me. Show me that. How is it changing the character also? You could not show.
Yes, my lord.
Why? It is all there.
As it is written in the
Whatever is there in the WS is written in the. So you are saying this is all surplus.
It is all surplus, and it is.
It is only intended to delay the hearing of the suit. Yes, 2 points.
Yes.
Anything else?
Anything else? But the order which has been passed. That is there is some objection on my part.
Show me that.
Yes.
Very well. 2 points have been there. Third point.
Third point. Please page.
Yes.
Page 42, page 43, kindly. There is some objection on my part.
You filed a suit for, you said license, leave and license.
Recovery of first possession from the ex-licensee. This is under Easement Act, my lord. Where 7172 does not come.
Correct.
That is why. And he is mentioning this, and after that he has filed the Order 6 Rule 17 petition only for the consequential order.
Where is your plaint?
Yes, my lord. Page 12, my lord.
No, now 7-1 has been allowed, he says.
7-1 is anyone can deposit the rent at his own risk, my lord. But 7-2 petition is still pending. Where the relationship between plaintiff and opposite party will be determined, my lord.
Anything else?
And please see the order. That's why I am
on the order itself.
My order is that it appears from the on the other learned advocate of the plaintiff submits that it will nature character of the suit. But when it was shown in the written statement, no, it was changed the nature and character of the defense, which has been written in this that is submitted by the learned advocate, which is not at all permitted, sir. Because in the defense, in the written
what the court says that the plea of changing nature of character of the suit is not applicable here.
Yes,
as the written statement is going to be amended.
Yes, my lord.
Understand the language.
That what he has allegation is that on the other learned advocate for the plaintiffs submits that the instant suit has been preferred by the plaintiff by portraying defendant as a trespasser, ex-licensee in to show the instant amendment that has been proposed to be incorporated.
How can you control his written statement? How can you control by your plaint what will he write in his written statement?
No, that will be proved after 7, at the time of 7-2 hearing, that will be proved because the relationship will be determined. Whether he is a tenant or...
How a 7-2 application is maintainable at the first instance when a defense under section, when a suit is not filed under section 6? I'm yet to learn.
My lord.
So that part I am with you. That when an application is not filed under section 6, my suit is not filed under section 6, how can 7-2 come in? I do not know.
Yes.
Because at best occupational charges could have been determined.
Yes, ma'am.
But I am not going to make any observations because for that of making any observation, I need to serve on the other side, which I am not inclined at the present. Anything
But
else?
But he has not annexed any documents with his written statement or in the Order 6 Rule 17 petition, my lord. He has
I'm not going to
annexed any
prejudice him at this stage, but still then anyway, challenging the order dated 1st February 2024 passed by the learned Civil Judge Junior Division, First Court, Alipur, 24 Park.
the written statement to substantiate his claim, mine.
Whenever you go to the trial, you'll understand what I'm doing. I've kept your second point open, 7-2 point open.
Yes.
Once he decides 7-2, you can, well, you know what to do. It is entirely up to you. Yes, call the next matter.
My lord, I am for the applicant.
Yes, sir. Yes, sir.
Suit for permanent injunction. The present applicant are different number 1 and 3 on that suit. Now,
Suit for permanent injunction.
yes,
Filed by the plaintiff against the defendant numbers 1 to 3.
1 to 3, other defenses also. The present 1 and 3 are before you.
Declaration permanent injunction only permanent injunction.
Now, after interim order has been passed under order 39.
Ad interim order,
Ad
ex parte
interim
ad interim.
Yes, and direction was given by the learned court below.
You are for the
I am for the applicant.
plaintiff.
No, I am for the defendant. One.
Very well. Then
direction was given by the learned court to file all the documents and to serve copy upon the defendants.
Order 39 rule 3A has
3
not been complied with.
No, till date. And in the meantime, they claim that the property was recorded in their name. It has been reversed. The present record is name stand in the name of the different number 1, 2, and 3. Though 1, 2, and 2 and different number 2 has not appeared before the learned court below. 1 and 3 has appeared, and repeatedly we have said the interim injunction may kindly be vacated because the property has already
3A has not been complied with.
No. Only the order of the court has been sent to us. No annexure, nothing.
Where have you said that? Which paragraph? Which paragraph? Which paragraph? Where? Which paragraph? Yes.
The grounds, my lord.
No, not grounds, sir. Paragraph statement. It's a statement that you have to make, sir.
Paragraph 5, my lord.
Yes. Questioning the failure of the part
name of the present applicant now.
Neither here nor there, sir. Your only small issue.
Deeply obliged.
Which is your matter? Now, go down 3:30.
A short matter, my lord.
There is a 3:30 is there today.
I know, my lord, it's a 2 minutes matter, my lord. I tell your lordship, I filed this revision
For you, it
application.
is 2 minutes, sir. For me, it is not 2 minutes, sir.
It's 2 minutes. My lord, kindly see, the revisional application has been filed, my lord, in the nature of for expeditious hearing of the suit. My lord, my suit is the stage at the stage when I filed this revisional application, my lord, there was an application filed before the court for police help. In spite of having the injunction order in my favor, my area was being infringed by the defendant. That is why I filed the application for police help. Police help application was filed and it was adjourned for next 6 months. So, my lord,
208, application under 208.
my lord,
Application under 208.
under 208.
Yes.
Say 6 months. So I filed a revisional application. Now, during the
6 months.
6 months. During the pendency of this application, now that application has been disposed of. The revisional application still survives. But I am praying. I also is my prayer in the application.
Any
Let
caveat?
the suit be no caveat.
Any other injunction application pending?
No, no other injunction application.
Any interlocutory application pending?
The interim order DD. Interim order is there. Interim order is there.
Then I cannot direct the expeditious disposal unless all the you are aware, sir.
No, I know that. But along with the interlocutory
No.
application.
Then I have to direct the interlocutory application.
My lord, kindly do that. Kindly do that. The interlocutory application.
Which application?
My lord, my application. I give your lordship the prayer. My volume 2, page 145 is the injunction order. At page 147 is the order passed at the interim stage. Thereafter, the matter is still pending.
They are not appearing?
They appeared. They appeared.
At interim, thereafter what happened?
Thereafter, my lord,
Show me an order, they have appeared.
Thereafter, they were infringing this order. No, injunction order was not to interfere with my.
No, they have to be served. That is, you
No,
comply.
I have served. My lord, kindly see.
Show me order 39 rule 3A compliance.
না না এই তো অ্যাপিয়ার করেছে পুলিশ হেল্প তো পুলিশ হেল্প অ্যাপ্লিকেশন কত পেজ হয়েছে না না এটা তো কাল দিস ইজ দ্য লাস্ট অর্ডার পাস দে অ্যাপিয়ার্ড ইন देयर প্রেজেন্স দি পুলিশ হেল্প অ্যাপ্লিকেশন ওয়াজ ডিসপোজড অফ in their presence it was contested application.
Serve and come. I'll dispose it of. Serve and come. Upgrade it. I'll serve and come. So no difficulty. How soon can you serve?
কবে করে দেবে 1 week's time কলকাতা my lord kindly fix it in the next week.
Date time 22nd. এই কথা আছে. Since the order does not show they are appeared, so কথা আছে দেখো.
In the meantime, may I file supplementary?
Yes. As paid for leave is granted to the petitioner to file supplementary affidavit.
I'm filing. File করে দিচ্ছি. Well, I file it.
File it.
Yes, here now. May I have the leave, my lord?
Very well. Leave granted to file supplementary affidavit. Supplementary affidavit filed in court is taken on record. First of considering the submissions made by the petitioner, I am of the view that the copy of the considering submissions made by the petitioner and considering the materials on record.
এখানে আছে লাস্ট 1 সেকেন্ড পেজ নাম্বারটা বলো না না ও তো অর্ডার পুরো লাগানো
relief sought for.
এটা খালি এটা বলে দিন এটা
And since Mr. Dottu Lanet, senior advocate, appearing in support of the petition application, confines his prayer.
It is already in the
confines his prayer for expeditious disposal of the injunction application filed by the petitioner on 4th August. Filed by the petitioner on
date of the file
on 4th August. The put up petition is on 4th. Filed by the petitioner in August 2022. Expected it will be August 22. Or it is in March, or July.
No, August 22.
No, you may have affirmed it. Date of affirmation.
না তোমার এটা ফাইল হয়েছে কবে?
In August 2022, I am of the view that the petitioner should serve a copy of the aforesaid application on the opposite parties.
No.
Mr.
April 2024.
Yes.
April 2024.
2024, April.
April 2024.
No, the order 145 is August.
Oh, order. That order, yes, that order.
4th August 22. For interim order is 4th August.
Yes, August. So you must have
August
filed it prior there too.
August 22. August 22.
Copy of the application be served on the opposite parties having regard thereto. Let this matter stand adjourned and be taken up for further consideration under the same heading on 22nd of January 2022. The petitioner is directed to file affidavit of service on the return date. I'll dispose it of on that.
Yes, it's okay.
I will record it that you confine your submissions to early disposal. Yes, appellate side, audience side down. Yes, sir. Sir, wait, sir. The matter will be over, sir. Original side is there. The court is still in session, sir. There is no question of chamber now, sir. Wait, sir.
Lordship, in item number 1, I am for the petitioner. On the last occasion, Lordship had directed the one post for the system administrator to be kept vacant. I don't find the other side present today.
Today is 3:30. Come on Monday. Everything. Monday, I'm not passing the order Monday. Yes. All the list. Any urgent matter, so I'll take it up. Otherwise, I'll everything on Monday. Take it back.
Malad 6, Malad, if Malad can take it on Monday, Malad, because tomorrow is
all on Monday. Yes.
Malad, item number 2 has Malad has kept it on Monday.
All Monday, madam.
Grateful, Malad. Grateful.
Yes, what do you wanted to submit?